Good morning.
Good morning, everyone. Thank you very much for logging into this webinar on what qualifies as a dwelling for the purposes of the DPA. It's very much a hot topic, and we've both been advising on various different building types. And how we're going to approach it today is to mirror the structure we took in our article, which some of you may have read. So we're going to look at the non-DPA authorities first and what the key cases say about what a dwelling means. We're then going to look at the two cases, both at first instance, that deal with dwelling within the meaning of the DPA. We're then going to look at two building type examples, student accommodation and care homes, and see how the analysis might apply in the context of those building types. We'll then turn to a game where we'll look at whether certain types of building are or comprise dwellings or not. And finally, we'll do a Q&A. And we're very much, both of us are interested to hear any questions or other views arising. So please do put them in the Q&A and we can turn to those at the end.
Yeah, I think we've both, in some ways, been surprised about the interest in this topic, and at the same time, not very surprised because it is so fundamental. And we'll start here with the statute. So the key provision being Section 1.1 of the DPA. In order to bring a claim under this provision, the qualifying property needs to be a dwelling. So you'll see there that it's about the provision of a dwelling and whether or not the dwelling is fit for habitation when completed. But as everyone knows, a dwelling is not specifically defined within the DPA. So we need to first consider, is it a clear, unambiguous word which we all understand and can apply in practice, or is there ambiguity here, and how do we resolve that ambiguity?
And I think if we look at the statute, very much the temporal assessment for thinking about whether something's a dwelling is to be decided on at the design and construction phase. What is the intended use going to be? And that's very much because the provision is in the present tense and is concerned with applying the fitness for habitation test when that dwelling is completed. So if you've got a later change in use, that may be much less relevant than what actually was being designed and built in the first place.
Yeah, I think that's a key starting point, really. A lot of the questions we'll receive may involve buildings which have changed in use. And if there's no substantial construction to the structure, that's not relevant to the question of whether or not the original construction was a dwelling or not. So when starting with the statute, you apply the ordinary rules of statutory interpretation. So you start with those words that we just saw in Section 1.1, objectively assessed, are they clear? Are they unambiguous? The argument being made, and from which we're often asked to advise, is on that ambiguity, and where it's not clear, you can look to the statutory purpose and the mischief that the statute was intended to resolve. So we've headed this slide, ambiguity at the heart of the DPA, or opportunism. On one view, the word dwelling is not ambiguous, it's a natural word, and I think, as Sheriar will come on to, some of the cases and the judges have said, this is a natural word in the English language, it's not ambiguous. But what's happening here in the new statutory context under the BSA is we're seeing a lot of defendants seeking to argue that grey area or threshold type buildings, which are complex building types with different types of uses, are not dwellings and therefore do not qualify under Section 135 of the BSA. So what we're talking about there is the extended limitation period for DPA claims, which we've written on the slide, from 6 years to 30 years, which is transformational, really. And we're seeing many claims being brought now in respect of historic building defects, which again goes back to Sheriar's point that it's important to look at the time of construction, because a lot of these buildings may have changed in use. And we've got a few examples at the end of this talk where we've been asked questions. And although you might think they might not be a dwelling now, their original intention and construction was as a dwelling. So I think that's the starting point on the statute. And then we come to the authorities.
Excellent. So we're first going to look at how the word dwelling has been applied in other cases, because there are a lot of them. The first case, and in very much what may be the most important case, is a case called Eurotemp Ventures and Collins from 2001. Now, this was a case about whether a room occupied by Mr. Collins in the Viscount Hotel in Kensington could amount to a dwelling within the meaning of the Housing Act 1988, only if cooking facilities were available. So, first of all, concerned with a very different piece of legislation with a different objective to the DPA. Second of all, this was a case decided in the good or maybe the bad old days when each House of Lords member would give their own judgment. And so you had a lot of heavyweights in that judgment, Bingham, Steyn, Irvine, and you can actually look to each judgment and think what was actually central to the decision-making of each judge. How did they agree with each other? Very much now, we see either one judge or two judges in unison giving a judgment. And what we think the heart of Eurotemp is saying is what was reflected in Lord Millet's judgment. He gave the longest judgment and considered the facts. And what he says there in the first and second line is that a dwelling is a place where one lives and makes one's home. Now, that's a very common sense understanding of what a dwelling is. And when one looks at the other judgments of the House of Lords members, they seem to be making that same core and important point. Now, in this case, Mr. Collins had been living in the hotel for 13 years prior to proceedings being commenced. And that was at first instance before it got to the House of Lords. So in that case, it was very much an instance of long-term usage of that hotel room. And the Housing Act 1988 is very much focused at protecting, is concerned with a situation where there's potentially a tenancy and providing protections on that basis. The next interesting part of this judgment for our purposes comes from lines 2 and 3. They suggest a greater degree of settled occupation than reside. And as Nick and I are going to come on to with our examples of student accommodation or care homes, sometimes in the name or the contract, you'll see residency agreement, or you'll describe someone as a care home resident. And that in itself provides an argument that there are different shades of occupation, with reside being less or reside being more transient than somewhere you're settled and living consistently. And again, they applied dwelling to mean a place where someone sleeps and usually eats. So question whether you actually need kitchen facilities, but if you've got a bed and you live there, you're returning to that place as your center of existence, then that's what the House of Lords here was saying a dwelling would be. And on the facts, they held that a single room in a hotel occupied on a long-term basis could qualify as a dwelling, even where Mr. Collins didn't have facilities for cooking.
I think he had, there was a lot of discussion in that case about whether you need a kitchen. I think where the judges got to is they decided that that is not the key definition. It's not about cooking facilities or the absence of a kitchen per se. In that case, I think he did have a microwave and a toaster, and he would bring his own meals and heat them up in his room. But I think, as maybe the next case will show, that's not determinative, or not been considered determinative.
I think that's quite right to point that out, and that he could make food within his room, as Nick said. And in some of the later discussion in Eurotemp, where Lord Miller goes on to consider the old cases, there's a lot of discussion about the relevance of a kitchen, and in one old case it being described as the place where the family gets together and shares their meals and have conversations, and that being the very essence of the home, where people come and congregate and are living together. So the next case is again from the court at the highest level, decided in 2014. And Lord Hodge in this case considered Eurotemp and agreed with Lord Millett that there was a distinction to be drawn between dwelling or dwell and residence or reside. And he considered that as a general rule, and he was in the majority in that case. Quite unusually, you had a very significant minority in this decision, with two former presidents of the Supreme Court, where Lord Neuberger reasoned that he thought that dwelling and residence were really just synonyms, that you shouldn't draw such a deliberate distinction between two words of the ordinary English language. And Lady Hale agreed with Lord Neuberger's analysis, saying that dwelling should be at least as wide as residing. So this point about the degree of settled occupation is a point that can be applied in the context of the DPA. If you think about a sliding scale with a hotel where people might stay for a couple of days or potentially weeks, student accommodation where students will be there for months in term time education, care home residents who may be there for a number of years. As I said, there are shades of occupation, and this potentially provides an argument for defendants that people are merely residing in these places. They don't have their settled occupation there, either because their main home is elsewhere, or perhaps because they're actually there to receive services. But if you're a claimant and arguing for a wide definition of dwelling, you can draw upon the analysis of Lords Neuberger and Lady Hale to say that such a fine distinction shouldn't be drawn on those facts. So, in summary, you have to apply the word in the context of the statute being considered. And first of all, we can take a core meaning from those cases. Does the person live there? Do they make their home there? That's the point that really shines through from those Supreme Court and House of Lords cases. As I mentioned, you have to be extremely careful, though, about applying the analysis of those judgments or other cases in the context of the DPA. So, for example, in Eurotemp, the House of Lords were deciding the question of whether his hotel room, he'd had 3 hotel rooms since he began occupying or staying in the Viscount Hotel. They were concerned with whether his room, at the time when proceedings were brought, were a dwelling. And as I mentioned, that's a different temporal assessment to the DPA, where you're looking backwards in time to the design and construction phases. What was actually going to be built? Was that going to be in connection with the provision of a dwelling? Should the architect, engineer, D&B contractor have had in their minds that they may have owed a DPA duty? And so,
I've been asked to move closer to the mic so that we can be heard.
Thanks.
We will do. Thanks for that, anonymous attendee.
So you need to be really careful when considering this other legislation. And this is a point made in one of our key cases under the DPA, Rendlesham, which Nick is going to come on to explore. We finally mentioned there are many other non-DPA cases. One is a Court of Appeal criminal division case called Orange Punza, and that was a question of whether a hotel room was a dwelling at the time of a burglary. So again, was the room in question a dwelling at a later point in time to design and construction, time of a burglary? And there was an indication in that judgment at paragraph 15 that hotels are generally used for commercial purposes, where stays are necessarily transient and short-lived. However, a long-term use of a hotel room could make it a dwelling. But the judge said in that case that much will depend on the actual use, occupation, and configuration of the rooms in question. So everything also can turn on the specific facts of the case in question, which will be important. And another case decided at first instance in the King's Bench Division this year about whether a room being used to house asylum seekers and their families could constitute a dwelling for the purposes of the Housing Act 1985, to which the answer was no on those specific facts.
And we'll turn now to the DPA authorities. But it's worth bearing in mind that so we only have two DPA authorities specifically on the question of the definition of a dwelling. I think it's our shared view that courts will pay quite significant attention to the cases we've just considered, or at least Eurotemp and Lewisham, because they're decisions of the highest courts considering the natural and ordinary meaning of dwelling. But then you'll need to move to how that definition should be defined and moulded to the specific statutory context of the DPA. And for that, we can look at the two cases that we have. The first is Catlin Estates Limited and Carter Jonas. Ostensibly, this is concerned with a shooting lodge and whether or not that building is a dwelling for the purpose of the Defective Premises Act. It was constructed to be quite a leaky building. I think in the judgment, that water would enter through the roof into the bedrooms and you would have wet ceilings. A lot of the discussion in that case was whether or not it was disqualified from being a dwelling because it was used partly for commercial purposes. The owner would rent out the shooting lodge for shooting parties, but he would also use it with his family and entertain business associates there, not at cost. So there was analysis of whether that's relevant or not. Where that came from is the preceding Law Commission report, which came before the DPA. And there was discussion in that report about whether or not there needed to be a change in the law in the context of commercial or industrial premises. And the Law Commission said that the law in respect of commercial industrial premises did not need changing because commercial parties usually had the benefit of their own professional advisors. But the law did need changing in respect of those purchasing dwellings. So that argument was made in Catlin Estates, and the judge came to the conclusion, which is summarized on this slide, that a dwelling house is a building used or capable of being used as a dwelling house, not being a building predominantly for commercial or industrial purposes. There are two aspects of that. The first might appear circular at first blush, a building used or capable of being used as a dwelling house. But it's, I think, in our view, of more utility than it might first seem. So the reference to a dwelling house there, we would say is a reference to the core and the core meaning of a dwelling as defined within the non-DPA authorities, a place where someone lives and makes their home. That first limb of the test is requiring a dwelling to be a building or residential unit which is capable of being somewhere that someone can live and make their home. The next aspect of that test is that it's not predominantly commercial or industrial. As I say, that's taken from the Law Commission report. His Honour Judge Toolman added some gloss to that which is the word predominantly. That's not in the Law Commission report. And we suspect that we will be seeing arguments to the effect that certain buildings aren't dwellings because they're commercial or industrial. Whether or not that is a workable test, we'll come on to later. But on the facts of this case, it was decided that the relevant building was a dwelling. And if you go into that judgment, what we really had there, whilst ostensibly a shooting lodge, was a 9-bedroom house with ensuite bathrooms that was used by the owner, and it may have been rented out at some time. But the intention upon construction or arranging for the construction was certainly to construct a dwelling. The second case is Rendlesham Estates Bar Limited, a case of Edward Stewart's, Justice Edward Stewart's, where there's some good and interesting analysis on a definition of a dwelling. That case concerned a tower block, and one of the essential questions was whether or not the tower block itself, as the whole building, was a dwelling, or the independent flats were dwellings, and what about the communal areas in between the flats. There, Edward Stewart's adopted what we've called a spatial test. He focused on specific residential units, so the flats, and carried out an assessment as to whether those residential units were capable of being used as a dwelling, applying Catlin, and introduced what doesn't appear in Catlin is perhaps an additional test of exclusive possession, which we can come to consider later, and whether or not that's useful or readily applicable, and also what the meaning is of exclusive possession. In Rendlesham, Justice Edward Stewart's discussed exclusive possession as being at least functional exclusive possession, because what we'll consider with student accommodation and care homes are buildings where often the residents do not have legal exclusive possession in any sort of land law sense, but they do have functional exclusive possession of their rooms, but they inhabit those rooms under licenses often. So these are the two key cases. They both apply the core definition of a dwelling under the non-DPA authorities, a place where someone lives and makes their home. And they add some DPA-specific nuances to that, which, from the perspective of potential defendants and claimants in disputes about whether or not a building is a dwelling or not, provides options for arguments and different ways to go. And I think we'll come on to discussing and weighing up the merits and demerits of those arguments a bit later.
Great. So we're now going to look at applying those authorities to two specific examples, being one, student accommodation. So those are typically study bedrooms, either one or two occupants, along a corridor with shared kitchens and bathrooms. For many of you, that may be able to picture that in your mind from your uni days. And invariably, those are usually for a year or less on a license. And of course, on the other hand, care homes, where residents typically live there to receive services of care, they too are probably there on licenses, and maybe it's probable that the care home operator has the right to enter the room or move the residents in theory. And both of these types of buildings are usually operated by commercial parties and usually for commercial purposes. And to our mind, one should apply very much a two-stage analysis, which is to first ask whether the whole thing is a dwelling, and if not, well, does it comprise individual dwellings through the rooms, floors, corridors, etc.? First question, in our view, on the current state of the law is going to be very difficult to sustain if Rendlesham is applied by a subsequent TCC judge. Because in that case, as Nick mentioned, he held that a tower block of flats was not a single dwelling. And you can see from the bottom of the slide in bold there that he rejected the suggestion that the two tower blocks, which were the subject of the claim in Rendlesham, could constitute a dwelling. And his reasoning appears there in the last sentence, which is that each block was a building that contained a number of separate dwellings. And of course, that is fact specific to that case, where, as you can see from the middle of the text there were various different apartments held on leases. And so in his view, because different occupants had exclusive possession of their own different apartments, it was very difficult to say that the overall building was a dwelling for the purposes of lots of different leaseholders.
And there are probably two additional points there. We say probably not because the analogy between tower blocks of flats and student accommodation buildings or care homes is not a direct analogy, partly as a result of the exclusive possession point. Students and care home residents may not have functional or exclusive possession of their room, or if they have functional exclusive possession, they may not have legal exclusive possession. But the second point is whether or not a student's room is capable of being used as a dwelling. If it is just a simple bed in a small room, is it necessary for them to, are there bathroom facilities elsewhere? Is there kitchen elsewhere? Does that expand the spatial scope of the definition of a dwelling in these kinds of buildings? Arguments could be made to the effect that you need to look for the basic residential unit. That could be your corridor, rooms, bathrooms, and toilet, and kitchen. We'll get on to the question of cluster flats at the end of the talk, which is an example of a different type of student accommodation. So it's not clear cut by analogy, but Rendlesham at least gives us some guidance here. Yeah, I think. And then moving to the second question, if we think that the whole building probably isn't a dwelling, applying Rendlesham, does the building contain individual dwellings, and what is the significance of that? It's probably worth saying at the start that a claim under the DPA can still be brought in respect of parts of a building which are built or constructed in connection with the provision of a dwelling. That was discussed in Rendlesham in the context of communal spaces, corridors. If there are defects to those areas which are considered to be constructed in connection with the provision of a dwelling, which a corridor or fire escape route most likely will be, a DPA claim usually can be brought in respect of those areas, even if they are not part of the dwelling itself. But the basic point is you need to find a dwelling somewhere, regardless of the spatial nature of that dwelling within the building. So in terms of whether student accommodation buildings and care homes contain individual dwellings, there are really two approaches that we've set out here. Claimants will be making a common sense argument based on the natural and ordinary meaning of dwelling. Students live and make their term time rooms their home. The argument will be it's not that complicated, and it's consistent with the DPA's purpose that those kinds of buildings are afforded additional protections, that they're fit for habitation. And there's a potential analogy with flats in Rendlesham. Whereas we anticipate that defendants will be making arguments potentially based on the Law Commission report and the reliance on that report in Catlin and the reference to it in Rendlesham to state that these kinds of buildings are commercial premises. They're for profit. The residents of the buildings do not have derivative rights that they can action themselves under the DPA. and they do not have exclusive possession of their rooms. They can be moved at any time, and the argument would go that's inconsistent with the policy under the DPA, such that these buildings do not comprise dwellings and cannot be considered dwellings in their entirety. It's probably evident from this that there are arguable points to be made on both sides, and we're seeing a lot of interest in defendants seeking to argue that complex building types aren't dwellings, and I think that's where we get to on our examples.
And I think just before we turn to licenses and the BSA, the third bullet there on the left-hand side, it's currently seems to be well accepted that a commercial owner of a block of flats can bring a claim under the DPA. And so it would seem inconsistent if the owner of care home or student accommodation in the same way, similarly being commercial and profit driven, couldn't make a claim. And I think the third bullet on the right hand side comes back to that degree of settled occupation point, as in many students will have a home, either their parents' home or their legal guardian, which is their dwelling and to which they return, not during term time. And so, as Nick said, I think the arguments are plentiful on both sides, and it really is genuinely finely balanced as to where the courts are going to take us.
Yeah, and the arguments will potentially latch onto that nuance we discussed earlier between residence and dwelling, whether or not there is a nuance between the two. And you might argue that a halls of residence, a purpose-built student accommodation building, is something different to what you might usually conceive of as a dwelling, and it has some sort of service aspect. Maybe the same for a care home as well, where all or most of your meals are provided for, and you're looked after.
Yeah, and I think the problem potentially arises from the fact that the Law Commission report was saying that commercial parties didn't need additional protections because they had the benefit of legal advisors in their contracts. And if you're very much thinking of a homeowner entering into a contract with a builder or an architect who doesn't have these kinds of protections, will need the assistance of the Act. But I think what's difficult in those circumstances is that in light of BDW and URS, developers are owed duties under the DPA, and commercial landlords, it seems to be well accepted, can bring claims under the DPA. So it's rather double-edged. The license point, in our view, no one applies precedent blindly. Rendlesham was obviously concerned with leases. The judge was very much aware of the wider distinction. He talked about schools and hostels with dormitories in a footnote. And those aren't really what we're concerned with here, which is student accommodation and care homes. And most licenses deny exclusive possession. And so there is a reasonable argument based on Rendlesham and how the judge applied the central reasoning of exclusive possession, that rooms in student accommodation or care homes aren't dwellings. But to our mind, there's also a reasonably powerful argument that what matters is whether you dwell there and not the functional status of whether you're there on a license or a lease. And perhaps arguments could be made about who is actually owed a duty under the DPA, because in these circumstances, it's very much the commercial entity who funded and developed the works, the freeholder or the long leaseholder who might be a claim. It seems very unlikely or impossible that the care home residents or the students are going to band up together and bring a claim. And so whether it actually matters that they don't have a duty owed to them under the Act, it's not clear if that should actually matter, and whether the duty holder being different would stop a claim in those circumstances. The other really interesting point arises out of the Building Safety Act and the definition of residential units. Now, Parliament recognised that residential units could comprise, on the one hand, dwellings, on the other hand, units of living accommodation. Now, something has to be a unit of living accommodation. You've got to give colour to that meaning. And what Parliament seems to have been suggesting is that there are places where you can live that don't constitute dwellings. And as everyone on the call will know, the BSA expanded the limitation period under Section 1 claims from 6 to 30 years, but also introduced a new duty under Section 2A to catch, for example, renovations of properties rather than their creation, and attaching a DPA duty to those circumstances. Now, if Parliament is using the word dwelling in a later provision of the Act, there's a principle of statutory interpretation that you give a consistent meaning to that phrase throughout the Act. And so in sections 130 and 115, the defendant could say, dwelling in those provisions should bear the same meaning as the provision later on in the BSA that introduces Section 2A. And if you apply that consistent meaning, then rooms in student accommodation and care homes are better categorized as residences or units of living accommodation rather than dwellings. And that's going to be something that's going to have to be wrestled with by any court considering the matter afresh. The explanatory notes do talk to the BSA, do talk about this, and actually say that shared facility student halls are more likely to be units of living accommodation. But one has to be very careful about relying on those explanatory notes, given that they're not endorsed by Parliament. And also, as the Court of Appeal held last year, and in the case of Adriatic, certain provisions of the explanatory notes actually postdated the Act. And so one could say, why should those influence the interpretation of Section 1 of the DPA when they themselves postdate the introduction of the provisions of the Act? So it should be checked whether the relevant explanatory notes actually postdate the BSA or not. And then the other very important consideration is the URS and BDW case decided last year in the Supreme Court. And here we had at least 3 judgments, so close to 5, but not quite, where it was Lords Hamden and Burroughs who gave the main judgment, and Lord Leggett then gave a concurring further judgment. And there are interesting observations in that case about the policy of the DPA. And we could probably be here all day talking about what the purpose of the DPA actually was and who it was intended to protect. There's a very interesting statement that the purpose of the DPA is better served if the DPA duty is widely rather than narrowly owed. And in Lord Leggett's judgment, at paragraphs 202 and 205, he said specifically that it would be wrong to treat the duty solely being aimed at consumer protection. Really, it's about improving the quality of construction of new housing. I think a note of caution is necessary here because the Supreme Court were considering the issue of whether a developer could both owe and be owed a duty simultaneously. They were not in any sense considering how widely the word dwelling should be defined. And one can see there in the first line, the DPA duty is widely owed. And so one can see how that's relating to whether a developer should also be owed a duty so that it could then, for example, pass on claims within its supply chain. And so one needs to approach these observations with caution. They're applied in a different context. But there is certainly an argument to be made that the judicial wind is flowing in predominantly one direction and seeking to give life to this statute from 52 years ago when it came into came into effect, which is doing the heavy lifting under the BSA because it's the only cause of action that extends, well, one of the only causes of action that extends 30 years back in time. And so one might argue is, well, if you're taking a broad approach to the DPA generally to try and achieve its purpose, then why not define dwelling broadly in the same way? But again, I think there are reasonable arguments against taking these citations too far, given the subject matter at issue.
And I think in the context of the Supreme Court taking this broad approach more generally, there might be arguments to the effect that defendants should not be using the definition of a dwelling as a backdoor to then again narrow that duty, although the questions are inherently slightly different. So arguments can still be made. So tying all of that together, I think our hope and wish is that the courts can provide some guidance as to a workable test, but at least stepping through what we think the authorities tell us, your starting point is that the whole building is unlikely to be a dwelling, and there we would rely on Rendlesham. The better analysis is to look at the individual rooms or residential units. The points Sheriar's just made on the BSA might be relevant there, and that question is more finely balanced. You'd look back at the natural and ordinary meaning of a dwelling under Eurotemp, and also look at Catlin there to consider whether or not those rooms or residential units are capable of satisfying that natural and ordinary meaning. That's where we see most arguments being made. And then finally, there needs to be some way to tie all of this together so that the industry can work out whether or not we're dealing with a dwelling, and disputes in this area can be much more easily resolved. And unless you have anything on concluding that, we've got an exercise or game, which is to consider some different building types and whether or not we think they're dwellings or not a dwelling, some easier than others. I think, as will be aware to everyone, there are varieties of different complex building types, and this is a way of having a look at how the authorities might apply in practice. So starting with an easy one, a supermarket, it will come as no surprise to any of you that a supermarket's not going to be a dwelling. It's purely commercial. There's no residential element. No one's living there or making it their home. It was never intended to be a dwelling under the Act. I think that's probably one of the easiest arguments around.
Okay, what about a hunting lodge, as in the Catlin Estates case, where the owner uses it for his family and to entertain business associates? Is that a dwelling? I think on true analysis, it actually depends. It's fact specific. The Catlin Estates case says yes, but it was influenced by the facts, which were, I think, from Nick's diligent research before this talk, there were indications earlier in the judgment that it was a very big shooting lodge with rooms and en suites, and so you can potentially use it as a home. You're living there with you occupy or reside there with your family, or dwell there, and entertain associates. So in that sense, because it had that family use, it's again not being used predominantly for commercial purposes, and capable of use as a dwelling house. If it's got rooms where you can live and en suites, and you can functionally use it as effectively a house on the grounds of your estate, then again, applying Catlin, that's capable of being used as a dwelling house. So in those circumstances, the answer would probably be yes.
But then turning that on its head, if you take the example of, say, a manor house, which has a separate shooting lodge, it's quite a niche example, but it might happen. You've got a manor house with a separate shooting lodge. That lodge has no bedrooms, no living facilities, really. The approach in Rendlesham, so in that case, Edward Stewart considered whether or not a detached house with a separate garage and stables, whether that garage and stable is part of your dwelling, and came down on the conclusion that they're probably not part of the dwelling. The dwelling itself is the detached house. By analogy, that would likely apply here as well. So it really does depend. But the facts of Catlin are specific. He asked his builder for a really good house with 9 bedrooms, all with en suites. So you're much closer to a dwelling than you would be if it's just a pure shooting lodge. A more difficult one, which you can have, which can come in a variety of shades, is starting with hotels, but hotels with complex uses and functions. So you can have a hotel with long stay residents, that might be like the Eurotemp example, but you can also have hotels with apartments, which are let out on monthly or potentially yearly bases. Again, it depends. There are arguments both ways, and I think the key question will be the intent at construction of that hotel. You have the sliding scale from hostel with bunk beds up to serviced apartments, effectively. I think it would be much easier to make the argument that your serviced apartment is a dwelling and was always intended to be a dwelling than your hostel with bunk beds. But when you're in that middle ground, there are going to be arguments both ways, and parties will have to rely on the authorities in either common sense or inventive ways to make the argument that they're trying to make.
So a room in a care home where they've got all their belongings, they may treat it as a settled home, but staff can enter to give them care throughout the day. Is that a dwelling, not a dwelling, or it depends? I think as we've seen from the earlier analysis, it obviously depends and is an open question ripe for determination. It looks like a settled home if you apply the meaning of Eurotemp. And you might say that the DPA generally favours a wide duty and you should apply a wide definition of dwelling as a result. But on the other side of the fence, it's 85% of care homes approximately are run for profit. Care home residents live in care homes to receive services of care, and they very much likely don't have exclusive possession if you apply the full rigour of that term as in Rendlesham. So very much looking for an answer from the courts on this difficult point.
Cluster student flats. So this was foreshadowed earlier. What we're talking about here is, I think you have a distinction between your sort of halls of residence where you might have many rooms along a corridor, all sharing or potentially en suite, but usually all sharing bathroom and kitchen facilities. When we talk about cluster student flats, we're talking more about 4 to 5 bedrooms sharing common amenity spaces, living rooms, kitchen, and bathrooms, often provided under a license. It depends. I think there are two analyses. Either you have the whole cluster as a dwelling. It's akin to a household or a home with multiple people living in bedrooms, sharing facilities, even if they lock their own rooms. The dwelling is that entire residential unit. Alternatively, applying Rendlesham, the argument could be made that each individual lockable room is a dwelling itself. Whether or not either of those analyses is correct might not be important, given that a claim under the DPA can be made in respect of parts of that building which are built in connection with a dwelling. So I think, as I said earlier, What's really essential is if a claimant is trying to make a claim, is to find a dwelling somewhere uh, and ensure that the parts of the building that you're seeking in to claim in respect of can be argued to be in connection with the provision of that dwelling. How far that extends, again, will be a matter of debate, but it's slightly common sense. So if you're in a cluster flat, your kitchen and living room and bathroom are very likely to be built in connection with that bedroom. If you're talking about individual flats, the common hallway, fire escape, again, is very likely to be in connection with its provision. It's a bit more difficult if you have, for example, a large student accommodation building with a supermarket at the bottom. Whether or not that supermarket is provided in connection with the dwellings is more difficult. In my view, it's probably unlikely, even if it's part of the same building fabric. But then it depends what exactly you're claiming for. Is the cladding across the entire building, including the supermarket, for example? That might be determinative.
And our final example throws a bit of magic in there, in possible celebration of the new series of Harry Potter that's coming out. We've asked whether Harry, Ron, Neville's dormitory rooms in their Gryffindor tower, could that be dwelling? And what about where Harry lives in book 1 under the cupboard with the spiders in the Dursley home? Could that be a dwelling? The Tale of Two Spaces. So taking them in reverse order, in Rendlesham, the judge may have been thinking about Harry Potter because he said that a broom cupboard in a one-family house counts even if no one lives in it. So after Harry turns 12, he's no longer living in it. But that either is a dwelling or is part of the broader dwelling in the home. So that's fairly clear cut. What about the Gryffindor dormitory room? Is that a dwelling? And that's really genuinely quite difficult. This is more akin to the type of accommodation type that the judge in Rendlesham footnoted that he wasn't considering. So schools and hostels. I think if you asked some of the Gryffindor common room whether they were living in a dwelling, they would say yes, but that's not the question. The question is, what does the word mean in the context of the statute? And does the shared use of the Gryffindor common room change the analysis, or is this a place where they make it their home? And I think if you asked Harry himself, I think without question he would say Hogwarts was his home, and the very essence of his existence, the place to which he returned every evening to sleep and live and hang out, was that Gryffindor dormitory room. So I think that's a reasonably compelling argument that that could be a dwelling. So that concludes our game. We are now going to consider some of the questions that were asked prior to the talk and then go on to some questions in the Q&A chat. So the first question is about cluster student flats and HMOs, which Nick is going to address.
So cluster flats, I've already considered as part of the game. I think it's my view that the entire cluster is the strongest candidate to be a dwelling itself. What you have there are all the essential ingredients for that cluster to be capable of being used as a dwelling. You've got your kitchen, toilet, amenity spaces. If necessary, it could be argued that the individual lockable rooms are dwellings. You're applying Rendlesham and Eurotemp there. But as I say, it may not be necessary to make that argument. Yeah, it might become academic. HMOs, I think the important point to stress here is that temporal point we made earlier, that what you're considering is the intent at construction or arranging for construction. A lot of HMOs, at least in my experience, have been subsequently converted to HMOs from domestic detached dwellings, which may have been in individual households to begin with. Most usually, you would expect a HMO to be considered in a similar way to a conventional household, multiple bedrooms, sharing common living facilities as an entire dwelling. Again, very similar to cluster flats. If necessary, arguments could be made that the individual rooms themselves are dwellings, but it may not be necessary to make that argument.
Question 2 is mainly about evidence gaps. So firstly, given claimants can now bring claims retrospectively for up to 30 years, how do you see courts dealing with gaps in evidence where documentation may be incomplete or no longer exists, particularly in cases where properties have already been remediated and new evidence cannot be collected? And I think the answer to that is that the burden is on the claimant. Records, records, records. You have to adduce and find the relevant contracts, the as-built layout in order to properly plead your claim. And that's obviously going to be difficult where you're going back to the 2000s and the 90s where email inboxes have been deleted, hard copy files have been thrown out, and the documents are very difficult to find. In the case of properties that have already been remediated, then you'd very much hope that there are records from before the remediation, which are going to be extremely important. Without that, it's going to be very difficult to show what the pre-existing condition of the building was. And we're both advising on claims at the moment where the records are very difficult to find. And it's obviously a case of reaching out to whoever may be likely to have had the documents, or even considering an application for pre-action disclosure in order to try and get those documents to plead a sustainable claim. The second aspect of this question is about whether the evidential burden on claimants changes with respect to a room-by-room analysis. And I think the answer to that is usually when you do your PAS 9980 reports and you get your expert reports on the condition of the overall buildings, the problems that make it unfit for habitation are almost always fire or structural, and those typically relate to the common parts of the building, so the external walls, facades, or the roof. And so since those defects should be widespread and affect most, if not all, of the rooms, then you shouldn't need to go on a room-by-room analysis, taking the words for or in connection with in the statute itself.
And finally, before we open up to broader questions, which feel free to put them in the chat, is buildings that are part dwelling, part commercial, and what approach should be taken to those. We've covered the essential response to this already. What's important here is that wording provided in connection with a dwelling. So you first want to look at whether what you're claiming in respect of can properly be considered as being provided in connection with a dwelling. So that, as we say, will be fact specific. And I gave the example of a student accommodation building with a supermarket. It depends on the defect that's being alleged. It depends on the exact commercial element of that building. But you want to start with a dwelling and then see how far you can stretch in connection with to your relevant defects. But we do expect there to be arguments around the thresholds of that. And that's the conclusion of our slides and what we plan to talk about. We've got a few questions in the chat that we are happy to answer now. I think we'll start with we've been asked, to what extent do you consider that the right to vote in a particular location would be relevant to the question of residing/dwelling? It's an interesting question. That gets to, in my view, the question of whether it's you're most concerned with the individual occupying or living in the relevant space, or are you concerned with the building itself, the dwelling, and the characteristics of that building? I don't think a right to vote would be determinative or necessarily relevant. I think what's more important is the characteristics of the building, whether that building is capable of being used as a dwelling, um, regardless of where the, the the person living in that building votes. I don't know what you think, Sherry.
Yeah, I think I agree with all of that. And I think in homes and apartments, you might have the right to vote if you own the property legally or equitably. But if you don't and you're residing somewhere, then I don't think it should fully change the analysis. Another question we've been asked is about purpose-built student accommodation and whether it can be argued that the real purpose is education, and if so, how. I think it certainly can be argued. What we discussed in our article is that the provision of services itself isn't mutually exclusive to dwelling somewhere. And in a footnote in the article, we mentioned that everyone orders things on Amazon these days. They get takeouts from Deliveroo or Just Eats. And so in ordinary occupation, you're in receipt of services. So you can make a reasonably powerful argument that they're not there to just live and make their home. They're there for a specific purpose, which is to facilitate their education. But at the same time, it's difficult to see why that should be a trump card in law and in fact to the fact that they're making it their home.
We have also been asked, what if a supermarket had been converted from a dwelling, such as a corner shop? Would there also be an in connection with argument, as it may affect nearby dwellings and the connected terrace properties? A point that comes out of this, which we may not have touched on yet, is on conversions and changes to existing dwellings. So if there is a substantial conversion to a property, that will create a fresh dwelling under the DPA. So if you're carrying out further construction works and modifying a building significantly, that will create a fresh dwelling. So it depends the extent to which there has been that kind of conversion. But otherwise, as we said earlier, the important time of analysis is the intent at the time of constructing a building. And that might move into the HMO's question, where we've been asked, in case of a large house, which was previously a single dwelling, where that's converted into a HMO with individual lockable rooms, would the conversion works be in connection with the provision of the dwelling? What do you think? It depends on the conversion works, how substantial they are. As I said earlier, I think the better analysis on HMOs seems to me that they're considered akin to households, but it depends. If a HMO is converted in such a way, I mean, individual lockable rooms, I don't think is sufficient in circumstances where they're sharing amenity spaces, they're sharing bathrooms and kitchens. I think that still encompasses the wider dwelling. But if there are really substantial conversion works, that could create a fresh analysis.
Yeah. So we've been asked if the webinar slides will be available afterwards. The answer is yes. And I think unless, Nick, you'd like to take anything, I think we'll wrap up there. Thank you very much for your attention over this last hour on this interesting and topical question. We hope you found the talk helpful, and we very much hope that you'll stay cool on this very hot day.
Yeah, thank you very much.